Good evening. It's now 6 o'clock, and I'm handing over to Dr. William Westhuizen. Thank you.
Thanks so much, Renier. Good evening, colleagues. Thank you for taking time out of your busy schedules to join the South African Medical Association at tonight's webinar that will focus on the benefits of implementing a trust structure to ensure longevity of your practice. A trust structure provides a robust framework for safeguarding and managing assets within medical practices. By placing assets into a trust, practitioners can continue to benefit from their practices well into retirement, while insulating themselves from a significant amount of financial risk. As we delve deeper into the intricacies of this topic, I'm confident that you will gain valuable insights from our expert speaker, Mobile Ngulani, an accountant with 15 years of experience in tax and accounting fields. Mobile served articles with KPMG and CHF Chartered Accountants and commenced his tax specialization career with PricewaterhouseCoopers. He is a director at Mediac, an accounting practice specializing in tax and accounting for medical professionals. He is a registered tax practitioner with SARS and a member of the SA Institute of Tax Practitioners and the SA Institute of Business Accountants. Mobile, over to you.
All right, thank you. Thank you, William. Good evening, everyone. Welcome to the webinar on trust as a doctor's formula for practice continuity and risk mitigation. I hope that this session will be beneficial to everyone as we explore on how a trust structure can assist in a proper practice setup. All right. Okay, so I hope everyone can see my screen.
We can see it. Thank you.
Okay, great stuff. All right, so just a brief background on myself. As William has said, my name is Mobile Ngulani. I'm an accountant by profession. I'm currently a director at Mediac, which is a specialist tax accounting and consulting firm for the medical practitioners. So we deal mainly with anyone in the medical profession, with our specialty being in structuring of medical practitioners from the ink stage to registering and building up trust structures like what we're going to discuss today. So just a brief rundown of
I think we lost Ngobile there.
Oh dear, that does seem to be the case, Renier. Apologies for all the attendees. We're just quickly dealing with some technical issues. I'm sure we'll get Nobile back as soon as possible. I hope he hasn't snuck off to go watch the soccer. I take it those of you attending tonight either aren't Bafana fans or are only finding out now that the game is starting at 7. So you've got more than enough time to join us for the webinar and then join in the watching parties to watch the soccer. We're trying our best just to sort this out. If you could just give us a minute or two, colleagues. So sorry about this.
Bye. Ngobeni, I
All
see
right.
you back.
Thanks so much, colleagues. Sorry about the technical difficulties. We managed to find Mr. Ngulani. Please continue.
All right, thank you. Can you see my screen?
We can see the screen. You can just full screen it on that side, and then we can.
Okay, great. Okay. All right. So sorry about the technical difficulties that we just had there. So as I was saying, that the discussion shall follow the definition of a trust that we've spoken about, the two main classes of trust, the parties to a trust, because in order for a trust to work, there has to be multiple parties to the trust. So we'll discuss who those parties are. We will discuss as well the four main types of trust. There's actually a whole lot more types of trust that we have within the Trust Property Control Act. But for the purposes of the discussion today, we will discuss the four main ones that are applicable to the medical practitioners. And then from there, we will discuss the advantages and disadvantages of a trust. Because in as much as we would like this evening to highlight the main benefits of the trust, we must also make the participants aware of the disadvantages of the trust. And after that, we'll discuss the trust structure for a medical practitioner. So given that we will now all have a working theoretical knowledge of the trusts and the types of trusts that we have, we will then now have a look at how all these trusts can fit within the structure of a medical practice to enable that practice to mitigate risks, ensure continuity, and save tax both at the practice level and at the individual practitioner level. From there, we'll talk briefly on the tax implications of a trust. We'll just touch on the main points because I think there's quite a number of tax implications that are there. We actually need a whole webinar on this, but I think we'll just discuss the broad ones without boring you with the intricate and technical details on the taxation. And then from there, we'll discuss the costs associated with the trust so one can get an understanding of what kind of costs they can expect when they decide to get into a trust structure. All right, so the definition of a trust is a legal arrangement created by a person called the founder by placing assets under the control of another person who is referred to as the trustee for the benefit of third parties who are the beneficiaries. So it's basically an agreement where a founder, which is the person that actually initiates this trust, places their assets under the control of the trustees, which are similar to the board of directors in a company. And all of this is done for the benefit of beneficiaries. So we'll unpack as well as we go on in detail each of these parties, the founder, the trustee, and the beneficiaries. So the document that sets out the terms and conditions of a trust is called the trust deed. So the trust deed is basically our main document that details exactly why we formed the trust. It details as well the rights and responsibilities of the trustees, as well as the rights and responsibilities of all the beneficiaries. So anything that we want to do within the trust will be detailed in this trust deed. Okay, so the two main classes of trusts are an inter vivos trust and a testamentary trust. So an inter vivos trust is a trust between living persons. So this is whereby a person during their lifetime cedes the ownership of assets to trustees, to a trust via the trustees for the benefit of the beneficiaries. So this is basically the normal trust that we are used to and that we deal with on a day-to-day basis. Right. The second trust is a testamentary trust. This is a trust which is set up in a person's last will and testament. So this one only kicks in on a person's death. So basically, the trust it only gets started when the person has passed on. So for example, with a testamentary trust, you could have all your assets in your name, but then you state in your will that at the date of your death, you would like these assets to get into a trust for one reason or the other. So for the benefit of our webinar today, we are going to be discussing the inter vivos trust, because that is the one that actually has the benefits while one is alive. Okay, so now we remember at the start, we spoke of our definition of a trust, which is an arrangement between a founder, who's the one that initiates the trust, a trustee, who's the one that manages and controls the trust, and the beneficiary, who ultimately benefits from the trust. So now we are going to unpack each of these parties in detail. So the founder is the one that creates the trust, so he's the one that actually goes out to have a trust registered either with attorneys or with accountants. The founder is one that has an intention around the trust, whereby they know what they want to achieve. Like say, for example, if the whole purpose of setting up the trust is asset protection, the founder will state on their trust deed to say that they would like to have the assets protected. They would like to have the income protected. So whatever objective one is trying to achieve with the trust is what is stated by the founder. The founder is also the one that makes the initial donation to the trust. So when a trust is opened, there has to be an initial donation, which is normally about 100 Rand or 500 Rand or whatever amount, just to kickstart some level of activity in the trust. So it is the founder that makes this donation. And thereafter, the founder then donates their assets into this trust. Because remember, the whole point of setting up this trust structure is to ensure that you do not have direct ownership of assets, but rather the assets be owned by the trust for various reasons that we are going to discuss as the webinar progresses. So the founder is one that also donates these assets. And bear in mind as well that we don't necessarily need to have one founder. You might find in some instances, you have a couple that is married in community of property, and they wish to open up this trust for purposes of protecting their children's interests and the like. They will then set up this trust whereby they are joint founders in the trust. Okay. All right, so we spoke about the trustee that initiates the trust. The next party within a trust setup is the trustees. So the trustees are people tasked with the administration and control of the trust. The trustees are similar to the board of directors of a company because basically they deal with all the admin, they deal with all the compliance and all the legal issues involved around the trust. The trustees are deemed to be people of a sound mind who always make decisions that are in the trust's best interests. So this is a very important point because in your selection of your trustees, you need to select people that will have your best interest at heart and will be able to make the decisions that will not be to the detriment of the beneficiaries. So these trustees can be individuals or corporates. So the minimum number of trustees in South Africa that one can have is 2. So the founder is allowed to act in a dual role. The founder can be a trustee and can also be a founder as well. However, the Trust Property Control Act states that within our board of trustees, we need to have what is called an independent trustee. So the independent trustee is someone that is not related to you by blood, someone who's not your friend, and someone who is a professional. It has been set up that way because an independent trustee is deemed to be a professional and independent person, whereby our trust is not just seen as our alter ego or as an extension of ourselves. Because you might find in some instances, there are trusts that are set up in order to hide the proceeds of crime, whereby a founder registers this trust, and then the trustees to this trust is the founder's wife, the founder's brothers and sisters, and the like. So in a strict sense, really, if we unpack that trust, there's no independence there because that trust is just a direct extension of that founder. And really the true sense is that they still control who these other trustees, what these other trustees do. So the moment there's an independent trustee, it then adds that level of independence and trust on the trust itself to say that it is not there as an extension of oneself or as an alter ego, but rather it is there for the purpose of genuine asset protection. All right, the third party to the trust is our beneficiaries. So these are people that have been nominated to benefit from the trust. So commonly, this would be the founder's descendants, parents, siblings, and the like. So it doesn't necessarily follow that one has to appoint their family, one has to elect to have their family as beneficiaries. You might find there's a helper at home, for example, that you've had for many years. He or she is now part of the family. You may elect to say you want to list them as a beneficiary in your trust for the good work and service that they've given you over the years. So it is really at the founder's discretion on the beneficiaries that they select. So the beneficiaries are the only ones that can benefit from the trust assets. The trustees cannot benefit from the trust assets except where a founder has made provision within their trust deed for the trustees to earn an income of some sort. So their benefit really will be limited to the income and not to any share of any of the assets or of the trust assets or income. So it is recommended to have what we call a discretionary trust. A discretionary trust is a trust whereby the beneficiaries merely have an expectation to receive from the trust. So the trustees are the ones who will determine the amount that the beneficiaries get. So there's merely just an expectation to receive and not a guarantee per se. So the trustees work with the independent trustee in order to determine what each of the beneficiaries get. The other type of trust that we have is called a vested trust. So in this trust, there'll be percentages that have already been listed on there to say X beneficiary gets so much, X beneficiary gets so much. Generally, I would advise against such kind of trust because once it's set up like that, there's a predetermined share of the trust that that person has. If that person gets sued or goes through a divorce or any other activity that would warrant them losing some of their assets, their share in that trust would be attached. So say, for example, the trust has got a 10 million rand property and this particular beneficiary is said to have a 40% share in the trust. In such an instance where there's litigation that has not worked in their favor, that property in that trust can actually be sold and their portion, which is the 40%, then proceeded to be given to the litigants. So it's very important that when we set up these trust structures, we set them up as discretionary trusts. What can then happen from there is that there's something called letters of wishes of the founder, okay? So the founder can then, over and above the trust deed, now give specifics on what they want to happen. So, like for example, we did a trust last week where the founder specified that the descendants, which are their children, when they get their first qualification, he's basically listed a university degree. They have to be bought a property. And when they get their first job, they have to be bought a motor vehicle. So that's the kind of nitty-gritties that you can actually specify in the trust, which is why these trust structures are normally referred to as ruling from the grave, because you can literally dictate what happens should you decease. Okay, so now we'll deal with the 4 types of trusts, because there's a misconception out there that a single trust structure is a solution, and that is certainly not the case. A single trust structure has got its own limitations, which we'll discuss later. So a multi-trust structure is a more solid structure that ensures protection of the assets. So the 4 main types of trust that we have are the residence trust, the family trust, the share trust, and the property investment trust. We'll then now unpack each of these trusts. So the first one that we are going to discuss now is the residence trust. So within this trust, only your primary residence should be in this trust. It should be the only asset that is there in the trust. So my primary residence is a house where I live in. There is an exception where one also has a holiday home that is not leased out to anyone, then that holiday home can also form part of the asset in that trust. So in the residence trust, both financed and fully paid up properties can be in this trust. So practically how we do it is, say, for example, you already have a property which is still under a bank mortgage bond, and you now wish to have this property registered in your trust that you have just formed. You then approach the bank and reapply for a mortgage bond on that same property. What the bank will do is they will treat it like any other new credit application and score you based on your credit profile. However, at the point of registration with the deeds office, that property will not be registered in your name. It will then be registered in the name of the trust. But remember, because the trust does not have any credit profile, which is why as the individual, you are the one who is scored. But the ownership will then be transferred to the trust. You then, as the individual, stand as a guarantor or stand surety for the loan. So the bank's interests really are not compromised in any way, because they know that if the trust technically is, because it's a trust that actually all owns the property, they know that if the trust is unable to pay the mortgage installments, then the bank can come after you as the individual because you've acted as a guarantor for that loan. So everyone is happy because the bank does not get prejudiced in any way. And from an individual point, you have actually moved ownership of that trust, of that property, away from you and into the trust as part of your estate planning and assets protection structure. Obviously, the best way to actually go around this is to buy the property in the trust from the onset. Because in the example that I've just mentioned before, there's also cost implications, right? Because there's a change in ownership from you to the trust, we will then be subject to the normal transfer duty and the attorney's transfer fees. Because in as much as you are the funder of the trust, you are two separate legal persons, all right? You are a natural person with your own ID number, and the trust is a juristic person, not necessarily a juristic person, but it's a separate entity that's recognized for tax purposes, and it has a trust number. So because now there's a change of ownership of a property from this individual to this other entity, the normal transfer duties apply. So it's just unfortunate that a lot of the time, people get this information on trust when they already have the properties. So it may not always be possible to purchase the property in the trust from the onset, but that is the best. However, my view is that the cost of transferring this property from you to the trust are actually much less than the cost of not doing it. Because as we'll discuss later, the cost of having properties in your name, there is issues around capital gains tax, issues around estate duty when you are deceased. So you are better off having these properties in a trust as soon as you can. All right, the second type of trust is the family trust. So in this trust, we have only fully paid up assets. So there is no debt that's in this trust. There is no financed asset that's in this trust, only fully paid up assets. So typically the assets that you would have in a trust, you have your furniture, your paid up motor vehicles, your jewelry, your paintings, bikes, boats, and of course caravans, if you live in Pretoria, that is. So like I said, your family trust is your vault. And the other important aspect of this trust is that this trust then becomes a beneficiary of your life cover policies and your pension policies. So remember, when you complete your forms on your life cover and pension, you need to specify who the beneficiary is. So most of us will give the details of our family, our spouses, our children, and the like. All right, it's all good and well, but let me paint you a scenario. We all do not know when we are going to die, unfortunately, all right? So at that time, you will have young children that you have then listed as a beneficiary of your life cover. you've got 10 million Rand worth of life cover, and you list your child on there, and you then die when that child is 19 or 20. Legally, that person can have a bank account, and that person can get that payout directly into their account. But practically, let's think about this. What do you think is going to happen when you drop 10 million Rand into a 20-year-old's bank account? Because I mean, look, if you think of what you were doing at the age 20 and think of what you could have been doing if you had 10 million Rand, I think it would just be a whole disaster altogether. So which is why it's important to have a family trust, whereby on my life cover or on my pension, I will state that the beneficiary of my life cover is my trust. And then within the trust, that is when you then dictate exactly what happens with the funds. Because once the funds land in the trust, the trustees are also controlling things. So the trustees, like I said again, once you have trustees of a sound mind, they will not take 10 million and drop it into a 20-year-old account. The trustees will take investment decisions that are for the benefit of the trust and for the benefit of all the beneficiaries as well. And this family trust as well also holds our investment and savings accounts. So if you have got any call accounts or other savings accounts where we have that extra cash, I would recommend that we do not have those in our names, but rather in the family trust. So the assets I transferred to the family trust by way of a deed of donation. So literally all you have to do is to draw up a list of the assets, list your furniture, your paid up cars and everything else, and just have a deed of donation that states that you have donated these assets to the trust. And then this will then be filed in your trust file, and it is then now known that these assets are now owned by the trust. So for things like furniture that don't have any registration certificates or whatever, the deed of donation works best. But however, something like a motor vehicle, that you'd actually have to make an actual change at the traffic department. Okay, the fourth type of trust is called the share trust. So the other name for this trust is a business trust. So this share trust is there just to own shares in private companies. This trust cannot be a shareholder in an Inc., which is the incorporated practice, which a lot of our practitioners practice under, because the rules of the Inc. is that at any point in time, only natural persons can be the shareholders of an Inc. So only shares in a PTY. Later on, we will discuss how we can actually incorporate a trust PTY structure into our Inc. for the purposes of having our practice continue. So within this share trust, there should be no other assets in this trust. We should only have the shares in a business, all right? And it's very important that we have no other assets in here due to the practical example that I'm going to give to you. So say, for example, we've got this PTY that we have. This PTY is trading, and this PTY is signing contracts. This PTY gets into a dispute either with a client, a customer, or with SARS itself. So especially with the SARS debts, SARS' first point is that they go after the company itself, all right? And then after that, SARS goes after the directors of the company in the event that they cannot recover from the company. So in this case, you would be the director, all nice and good. I don't have any assets in my name, so SARS can't recover anything from me. The last point of call is the shareholders of that company. So if you have this trust as the shareholder in the company, and this trust also has assets, then you have exposed those assets to creditors, which is SARS. So which is why it's important that this share trust, the only asset it has is the share certificate of this company that we have. All right, the last type of trust is a property investment trust. So this trust is there to house properties that are not my primary residence, and also not my holiday home. Both commercial and residential properties can be listed in this trust. And the reason why that is done this way, I will also give another example. So say we have this property investment trust, and this property investment trust actually owns our building where we run our practice from, okay? And then a patient slips and falls there. They get injured or they die because we have not left the the slippery sign on the floor. This person trips, they fall, they get injured. This person is allowed to institute a civil claim against us. And now, depending on the extent of the injuries, these civil claims can work out to be quite significant. So now imagine if we had not had this property investment trust, and we had had one trust whereby we had our house in there, where we stay, our primary residence, and we had our business shares in there, and we have this property in there, okay? If this civil claim is a significant amount that is actually worth more than the value of our practice building, it would mean that we have exposed our primary residence and our shares in the business to this civil action. So which is why now it's very important for us to distinguish between this property investment trust and the resident trust, in fact, and all the other trusts. So only properties that are of an investment nature should be in the trust. We can then take it a step further to look at tax efficiency, all right? It is my view that it is not very tax efficient to have these investment properties directly in the trust. Because remember, these are properties that are going to be generating income, all right? Because say, for example, you've got some Airbnbs or some other houses where you've got tenants. These are generating income if we house them directly in the trust. The trust tax rate currently is at 45% of the profits. So now potentially, we are looking at a taxation of 45% of the profits if we have these properties in the trust. So I would do it indirectly, whereby we register a PTY, which becomes our property company, all right? And then this PTY is one that gets to own the properties directly. However, the 100% shareholder in that PTY will be our property investment trust. So we still get to the same objective of protecting our assets. However, we are now being more tax efficient by using the tax rate of the PTY, which is fixed at 27%. So just to recap, have the PTY, which is our property company. PTY purchases these investment properties, and then the trust becomes the 100% shareholder in this PTY. So back to my example again that I used on a SARS action. If it gets all the way up to the shareholder will just be this property investment trust, and all it has are just its properties. So we're limiting our losses, because again, with these structures, it's all about loss limitation and tax savings as well. So yeah, so that's the 4 types of trusts that we generally have. All right, so now we discuss the advantages of having a trust structure. The first one is estate continuity. I don't know if you're aware, but once you decease and there's a death recorded at Home Affairs, every single asset of yours is frozen, including your bank account. So until the estate has been wound up, nobody can get access to a bank account, and also nobody can sell any property that you have. Only the executor of the estate can do that. So there's been many instances whereby people die and they've got lots of funds in their bank accounts, but now the family struggles to actually bury them because the funds are frozen. So with the trust structure, like I mentioned, that we recommend that you have your savings accounts and any investment accounts held by the trust. Once you decease, there is no freezing of the assets, because all that happens is that the trustees still continue transacting on the account, and they ensure that there's funds available. Because many times you find families get to have financial hardships. Whoever's remaining is unable to pay any school fees or living expenses because these monies are frozen in someone's account until that estate has been wound up. So at least they would, if we have these accounts owned by our family trust, then we do not have this issue of our assets being frozen. It just continues as normal. The other advantage of a trust structure is building of generational wealth. So with this, what we're saying is all our assets will be housed in this trust, okay? So once you decease, everything still remains intact in the trust, and the remaining beneficiaries can actually contribute more assets into this trust, and it becomes a trust that then gets to be passed on from one generation to the other. So that's why you find a lot of these very wealthy families, this is how they've managed to protect their assets and build generational wealth, because now everything is just housed in one pocket, which is the trust. Unlike when we have these assets in our names, when we die, these things are all over the place, because now all of a sudden there's relatives popping up, they want this, there's kids we didn't know about that are popping up, they now want their own share, and it just becomes a whole disaster. So at least if we have our assets housed in one place, then we can ensure that we build the generational wealth. The other advantage is protection of assets from litigation. Like I mentioned, we are a risk onto ourselves as business people, or even anyone for that matter. Because, for example, you could be involved in a motor accident whereby it is your fault. You just could have been having a bad day at work, at home. You're not really concentrating, and you get involved in an accident where someone dies. And you discover that you've actually killed the CEO of a company where that person was bringing home 20 million rand per annum, but now this person is dead because of your actions. That family is allowed to actually institute civil proceedings against you. So in an instance where you have a trust structure and all your assets are housed in the trust that we've discussed, legally, you do not own anything, nothing at all, zilch. So if anyone wants to then attach any assets, they cannot, because you don't own those assets. You have control over them, but you don't own them. So the same, with the medical claims, where one proves negligence, they can also institute the same civil claims. So a trust structure helps us to protect those assets. The other advantage is that assets in a trust are excluded from any divorce proceedings. So if one has a trust structure that they set up before they got married, those assets will be protected in the trust, and they won't be subject to any sharing of assets within a divorce. And it's also very important to have a trust writer that actually understands trust well. They must put a provision within your trust deed to state that any assets that the beneficiaries get from the process of a trust are also excluded from those beneficiaries' own divorce proceedings. That's just another way that one can protect their assets. The other advantage is protection of minors. You won't have any instances of any relatives wanting to come and take over assets once you decease, because we do have those unscrupulous relatives who then, there's a cousin or brother that pops up here and wants to take a vehicle and the like. We protect the minors because everything's there in a trust, and that trust has got trustees of a sound mind, and it's got also independent trustees. And one of the other big benefits of having a trust is the saving on the death taxes. So when we die, there's certain taxes that are applicable to us, okay? There's estate duty, there's capital gains tax, there's executor's fees. So the capital gains tax, what SARS looks at is, all right, you've got these properties or you've got these shares. When you acquired these assets, what was the value, right? At the time of acquisition. And then they also look at what was the value at the date of death. So if those assets have increased in value, then SARS taxes that increase in value. And that's what is referred to as the capital gains tax. And also there's estate duty. Estate duty will be 20% of a person's net estate. So if you've got life cover, say of 10 million, there's an exemption on the estate duty. I think it's about 3.5 million, but anything in excess of that is then taxed at a rate of 20%. That can actually work out to be quite significant, because 3.5 million may seem like a big number, but if you take into account the value of just your house and the value of any life cover that you have and add all that up, it exceeds that 3.5. So the 20% of that net estate can be quite a lot. There's also executors' fees, whereby if you have the executor of your estate, they also charge a percentage, normally about 3 to 4% of that. So those costs can work out to be significant, all right? So in those instances, SARS will require those funds, and the way that they can get them, if there's no physical cash or there's no actual liquid money in the estate, the remaining beneficiaries may have to sell properties. So which is why it's important to have a trust structure, because once everything of yours is housed within a trust structure, there is no talk of an estate. You don't have an estate because it is at nil. All right, so which is just one of the advantages of this trust structure. And then let's look at the flip side as well, which is the disadvantages of having a trust. So the first one is loss of ownership, because now that the assets have now moved to the trust, you don't own these assets anymore. All right, because there are a lot of individuals, I don't know if it's an ego thing or what it is that want to have to say, I own this, I own that. So if you're that type of person, this asset will no longer be in your name. You still have full control. So I'd like to emphasize that even with the trust structure, even if you don't have ownership of the asset, you still have control of the asset. So if it's a house, you still continue living in your house. You can renovate it the way you want, decorate the way you want. If it's your car, you can still drive your car and basically go anywhere that you want. You just don't have ownership of the asset, but you still have control. The other disadvantage of the trust is the administrative costs around the trust. Because the trust is an entity for tax purposes, we have to submit annual tax returns to SARS. So you will have to get the services of an accountant to prepare a set of financial statements for the trust and submit the annual tax returns. Then there's also an independent trustee fee, depending on your relations with the independent trustee. In some instances, one will just appoint their lawyer who won't charge anything to act as the independent trustee, which is fine, there's no cost there. However, if you specifically approached a firm of independent trustees, then you'll have to pay them their annual fees to act as a trust. And then the other disadvantage is the wrong choice of trust. Like I mentioned, that you have to have your trustees being people of a sound mind. So if you have a wrong choice of trustee, then it means that they will make decisions that are not for the benefit of the trust. And eventually what you sought out to achieve may not be achieved because of the bad decisions that they have made. So it's very important on who your trustees are. If it's family, just try and get someone professional who at least understands the workings of a trust and who won't have any malice against you. Okay. So now we've spoken about the trust. We now know the basics of the trust. We now know the different types of trust. We now know the advantages and disadvantages of a trust. And now we're going to discuss how a trust structure can work for the medical practitioner. Right. So basically, as you can see on the screen, we have all our 4 trusts. I'll start with the Inc., which is the incorporated company. So this is our medical practice that we have registered with the BHF, and there's a practice number. So this is basically where the clinical operation of the practice is. So when you see your patients, you see them as the Inc., all right? So ideally, this Inc. actually does not have any assets. It's just there to perform the clinical function. And then we have what's called a management company. So within this management company, we would then have our employees in the management company. Any equipment that we own is the management company. Any contracts that we sign are here, and as well as any lease that we have is in the name of the management company. All right. So with the management company basically is one that is going to be running the operations of the Inc. Okay, so remember, the Inc. is there as the clinical function, and the management company is there to run the operations, because basically all the employees, all the equipment, everything is sitting within the management company. So that's how the setup is. What that does, it gives us the flexibility for this practice continuity that we keep on repeating. Because now, say you are no longer there, okay, and your family wants to continue with the practice. What then happens is that the management company does not need to have medical practitioners as the directors there. So you can have your family as the directors of the management company that has all the assets, has all the contracts, and it runs the affairs of the Inc. So you can just appoint another medical practitioner within the Inc. And then this management company runs the Inc. So that's how we have this practice continuity. Because, and this structure is this way because we cannot have someone who is not a medical practitioner being within the Inc. So that's how the setup will be. So the management company will have the share trust that we discussed as being the shareholder. All right, so the shareholder with the share trust, this is also done for the protection of this asset. Similarly, all these structures here actually all work together. So each trust is a beneficiary of the other trust. So your trust deed must state that as part of your beneficiaries is any other trust that you own. So this now enables us to be able to have a flow of funds amongst these trusts. Okay, so to touch back on the family trust again, there's something called a pouring over will. Okay, so a pouring over will is a will that just says, at the date of my death, if I have got anything that is not there in my trust structure, it should automatically go to the family trust. So it's just a provision to ensure that if in any way we have forgotten to move some assets to the family trust, then at the date of our death, everything moves there, and we then escape all the estate duty issues that we were speaking about. So just to recap, management company runs the affairs of the Inc. Management company can have people that are not medical practitioners. This then ensures continuity in the sense that we can just employ a doctor in the Inc. and your family still has the control of that practice. And also you can grow the brand of that practice via the management company. And this company is 100% owned by the share trust. And then we have the other 3 trusts for the other classes of assets. Right, the tax implications of a trust. Trusts are taxed at a rate of 45%. So it's not advisable to trade within a trust. So back to the example that I gave, instead of having those investment properties directly owned by the trust and potentially being subject to the 45%, we then have those properties owned by PTY, which is 100% owned by the trust. Then the distributions to beneficiaries are taxed in the hands of the beneficiary using their tax rate. So what this means is that once the trustees determine that the beneficiaries are going to get X amount from the trust, then the distributions will be taxed in the hands of those beneficiaries once they receive them. So say our trust has made 100,000 and we decide to distribute 50,000 to the 2 beneficiaries that are there. Those beneficiaries will be taxed on that 50,000 in their personal capacities using whatever tax rates that they have. And the trust will only be taxed on the amounts that it retains. So if in this instance, if it does not retain anything, then there'll be no tax. So when donating assets to a trust, we ordinarily would be subject to donations tax. There's 100,000 exemption on donations tax every annum. So the best way to do it when donating any assets to a trust is to create a loan account between yourself and the trust to the value of the assets that have been donated in that trust. What then that does is that every year you will reduce the value of that loan account by that 100,000 donations tax exemption. Anything beyond that will be subject to donation tax at 20%. And then we look at the costs associated with the trust. There's a trust registration fees. So this is where you've requested an accountant or a lawyer to draw up the trust and lodge it at the master's office. They will then draw up the trust deed, complete the forms and lodge it. There's a cost to that. There's the independent trustee fee, which I've touched on briefly, whereby you've appointed an independent trustee. And then there is the accounting fees, which are really annual fees for the preparation of the financial statements as well as the tax returns. All right, so I think that pretty much marks the end of the presentation. So in summary, trust structures are there really for asset protection, and the trust structures are there as well to ensure that we save on the death taxes. So in as much as there may be some admin and cost implication to it, my view is the costs of doing so far outweigh the cost of not doing so. Thank you.
Kabila, thanks so much for an excellent presentation. It really was very, very interesting. I'd just like to find out, where can I get some of this generational wealth? And now that I see there are a couple of questions in the chat box, if you don't mind me reading a few and then you can answer them as we go. I see we've only got a couple of minutes left until Bafana kicks off. So let me give you the first one so long.
All right.
This is from Dr. De Witt. If life cover is in the trust, will the trust pay estate duty when you die?
No, a trust does not pay estate duty. So that's the whole purpose of us setting up the trust. It is to avoid this estate duty. Estate duty is only applicable on your estate, which is you as a natural person having assets in your name. Once those assets are housed in a trust, so in this instance, once the life cover pays into the trust, then there's no estate to talk about, and that life cover will not be subject to any estate duty. So that's actually one of the biggest benefits of the trust, saving on what we call the death taxes.
Oh, fantastic. Thanks so much. There's another question here. At a property seminar, I heard that one shouldn't transact in a trust due to tax costs. What are the tax implications of selling a primary residence in a trust?
Come again, William?
What are the tax implications of selling a primary residence in a trust?
All right, so the transaction in a trust, I touched on that as well, to say that you should not trade within the trust, rather go through a PTY. But however, if our primary residence is in our trust, the tax implications are just the same like any other normal disposal of a property, because it's the only asset that is there, and it's not a trading asset really, because we're just having trust for purposes of ownership. So the tax implications would just be the same, where you are still subject to capital gains tax like you would as an individual. That's the whole purpose of having it as a standalone in the trust.
Oh, perfect. The next question is, when does one register a special trust for a disabled dependent? At time of death or earlier?
A special trust is registered during the life of that dependent. So a special trust normally is in an instance where you've got a child, say, who has a disability of some sort, and you want to protect that child's interest. So it's actually best to register that trust as soon as you are aware of that disability or other condition, and it should kick in even before death. So it should kick in because it's meant to benefit that person during their lifetime, not necessarily when they passed on.
Oh, perfect. And I think a final question, and just to let the attendees know, if you do have any additional questions or the questions that we might not get to, we'll endeavor to get back to you after the webinar with some answers. The final question is, what happens if I want to sell property? Will the trust do it?
Yes, the trust will do it, because remember, you are also on the board of trustees. So you are also a trustee on there with the other trustees. So if you want to then sell a property, you'll be able to do so via the trust. Because while you're still alive, you are able to make decisions with the trustees, because it's really your intention that you should be listened to. So it's only after now, when you're no longer there, the trustees with the beneficiaries need to then make those decisions. But while you're still there, yes, you are able to sell your property.
Oh, thanks so much. And just again, thanks so much for a fantastic webinar. As we near the end of this informative webinar, I would just like to extend my appreciation to all of you for your active participation and engagement throughout the session. I would also just like to acknowledge our chairperson, Dr. Mzukwa, who's joined us. And I see a lot of familiar faces or names in the chat box. So I do thank you for joining us. I hope you found tonight's webinar to be a valuable resource, providing you with a deeper understanding of how a trust can assist you in both a personal and professional capacity. Kobile has shared invaluable insights, and I encourage you to explore further resources and seek professional advice to meet your individual needs. Good night, and go Bafana.
All right. Good evening. Thanks, William.
Thank you.